Hello, everyone. Good morning. Welcome to yet another LexTalk World Executive E-Meet. Well, I'm Ajay, your host for today, and thank you all for taking the time to join us. In today's session, the title is Data Privacy and the Shadow Data Minefield. And if that title makes you a little uncomfortable, a little nervous, it probably should. Ideally, to ease your fears and clear your doubts, we have an accomplished group of legal professionals and industry leaders with us, for this session, what promises to be an insightful discussion. It would be a great pleasure for me to introduce our moderator for today. For today's session is Mr. Abraham Martinez. He's Assistant General Counsel at Arista Networks Incorporation. Now, just to give you a brief idea about him, Abraham brings extensive experience in navigating complex legal and business challenges. And we are honored to have him lead today's conversation. With that, I would like to hand over the stage and the floor to Abraham. Over to you, sir.
Thank you
The
very
session
much,
is all yours.
AJ. Thank you very much, AJ. And yes, it is a really difficult minefield to navigate all these different types of data streams and data that are being collected as part of our modern world. And I have a great panel with me today. I'm going to ask them to go around and introduce themselves a little bit further. But before I do so, I wanted to make sure to remind everybody that what we say here today is a reflection of our personal opinions and not those related to our companies or who we represent in the rest of our day-to-day work. So Alesya, if you want to start and give a quick introduction, and then we'll go to Taylor, Ava, and Wayne.
Hi, everyone. Alesya Nasimova here. I'm the former global head of privacy and DPO at Brex. It's a fintech company specializing in corporate cards and spend management software and travel as well, and been in the fintech space for about 10 years now. So within the financial services, data is a big aspect of what we do. And so I'm excited to be here and share insights with everyone here.
Great. Taylor?
Morning. My name is Taylor Falls Olson, and I have worked in the health tech space, specifically medtech bidirectional data flow for the last 12 years at companies like Stryker, J&J MedTech, Google Verily, joint venture, Verb Surgical, and also Genentech. Most recently, I worked at Terumo, and I'm starting a new position next week. So I'm so excited to be here with everyone talking about this really important topic with you all today.
Thank you for joining. Ava?
Thank you, Abraham. So my name is Eva Kozlowska. My experience is in working with a big law, working for insurance and financial industry for over 15 years. I advised as a privacy counsel for fintech companies in development of a payment networks and also management of health sensitive information.
Great. Wayne?
Hey everyone, good morning. Wayne Kaufman. I'm Senior Vice President, Deputy General Counsel, and the Data Privacy Officer for a company called ORBCOMM. We track assets like containers and truck fleets globally around the world. I'm happy to be here.
Great. So we'll kick it off. I just wanted to kind of put this topic in a bit of an encapsulation here and say, when you're starting out thinking about this topic, it's really important to map your data flow. Map where you have your data, know what you have, what you're storing, what you're collecting, where it goes in terms of which companies have access and those types of things, who can touch it, who can access that data, and what the legal basis is for the data that you control. So that kind of as the very general high level thought process that needs to go into addressing this topic. At the same time, it's very difficult to comply with all of the rules around the world because there are so many differences to what different jurisdictions require. So we're going to start out on the topic of biometric data. So that's managing exposure from voice, behavioral data, facial analytics, AI-driven inferences, and some examples of that are what is required under BIPA and VPPA as examples of regulatory regimes that plaintiffs are using to bring causes of action. So, Taylor, I think that you can shed some light on this topic.
Yeah, that's right. And, I should have mentioned before entering the corporate law space, I worked as a prosecutor for 8 years. And so I really do enjoy monitoring the regulatory waves and looking at how to help companies build that into their products. Proactively versus doing so retroactively. And I think this is incredibly important right now as we're looking at the biometric risk horizon, and we're seeing a lot more litigation in this space, as well as a lot more innovation. So just to set that context up, unlike your password or a credit card number, your thumbprint or your face print, it can't ever be, reset. And so I think that's just a good floor for why the different state laws, the EU AI Act are considering this information highly sensitive data. And like Abraham said, you really need to know if you have any biometric data, if you've intentionally collected this highly sensitive data, or if you have unintentionally created inferred sensitive data. And there's 3 layers of risk that have been created somewhat from the litigation world. And the gold standard, or what I would say the gold standard from the plaintiff's bar, is BIPA, and that's the Illinois state law. The reason why I would say it's the gold standard is because it's the only private right of action where a private citizen can file a claim for a grievance that their rights have been violated. And they can get up to $1,000 for a negligent violation and $5,000 for a reckless or even intentional violation. And so you do see plaintiffs' attorneys taking on these class action BIPA lawsuits and
Taylor,
having
just real
a lot
quick,
of success.
which companies are subject to the BIPA law? Is it how is that determined?
So it's anyone that is collecting a biometric identifier. So
For Illinois residents, or what's the threshold?
For Illinois residents, yes.
Got it. Okay. Yep.
So it's a state law.
Yep.
So it's a state law, and actually right now at this time, the New York has a almost identical BIPA law that is in its 3rd amendment in front of the New York Senate. So that's why I would say it's the gold standard in privacy protection for consumers, and is, as many people know, across the US, we have a patchwork privacy law, but it's gold standard in protecting consumers. And when you have to develop a product that's going to be launched across the US, which it's hard to imagine a product that wouldn't be, that would just be state specific, you have to launch to the highest standard. So you have to build that product to the highest standard. And that's why I think it's really important that we think about this in the beginning. What are the highest standards of privacy laws? And so therefore, I think my number 1 recommendation is that you would build to the BIPA standard if you're intentionally collecting biometrics. And then I would just go ahead, Abraham. I'm sorry.
No, please. I was just going to move us on to the Video Privacy Protection Act and some of these legacy laws that were not purpose built for this type of data, but are being applied by plaintiffs. And then I'll ask Ava to go into some examples from her experience about biometric data. So please, Taylor, finish off here.
Yeah, the other thing I wanted to mention is that we've seen recent enforcement at the state level, such as in Texas. I think it's important to know that there's been biometric settlements in Texas. Google and Meta have had billion-dollar settlements, specifically in the biometric area, and it's required a separate level of consent. And so again, I think that ties back to your product development, where you really not only do you have to look at, where is your data, what kind of data are you collecting, but then I think you also have to look at and what consent did you have for that data. And there's going to be different consent requirements per state. And so that really requires your product development team and your engineers to probably be working with a very well-knowing product counsel to make sure that that's aligned. And Alesya,
it's really
I know
important.
you have more on that. Yeah.
No, I think it's just really important to think about building privacy and how you handle data into the DNA of your product. So if you're starting out at a smaller company, often there's a tendency to not think about these things, go fast, break things, whatever. But we just really need to make sure that we're thinking about privacy as part of the DNA of the company and the product development. So Ava, please give us some more examples from this area.
Sure. So Tyler, by the way, fantastic overview. What I would want to add is, and caution everybody to keep it in mind, that definition of what biometrics or sensitive data, rather, actually varies by jurisdiction. There are similarities, but it could be defined by a type, or it could be defined by type of information. It can be something also that we are going to talk about later, which is synthetic sensitivity. So looking at the data in a contextual way. And from enforcement perspective, I think a few things which are extremely interesting is obviously in the context of Illinois, in 2001, there was a case against Meta and Facebook, which was around exactly what I'm talking about, synthetic sensitivity. So Facebook had tagging suggestions, which allegedly created face templates. And this was without proper BIPA compliant notice and consent. So also specificity in those cases very necessary. The case that Taylor has mentioned, settlement in Texas. So yes, Illinois is the golden standard, but in this case, Texas Attorney General highlighted that facial recognition without authorization can also lead to enforcement actions in Texas as well. So the Illinois is not the whole story there.
Was there any use of the facial recognition data there that was particularly egregious, or was it just the collection itself was the thing that the court was?
Very good question. So this was a collection without authorization and volumes of the data that has been collected in that context. But that's a very interesting question, which actually brings me to another enforcement action, Rosenbach and Six Flags. So in that case, there wasn't actual injury, there wasn't any actual loss, but still it was recognized by within Illinois Supreme Court that lack of systemic controls and lack of clarity from a procedural point of view was actually sufficient for enforcement action. So you really didn't have to have any injury there, which is actually answering your question there. What I wanted to say is you really need to think about, in a context of companies that you're running, about every touch point where the data is being collected. And the fantastic illustration of that is actually railway fingerprinting gateway. So that was enforcement action from 2024. And I love it personally because this was essentially routine control, access control around biometrics, which was essentially truck drivers collected fingerprints for just faster transfer to through those auto gates. So that essentially highlighted this potential that, you know, even the routine situation of access gate in the workplace can lead to a biometric related litigation. So I really think that we are going to see much more enforcement actions in that case. And from a perspective, for example, of White Castle, the enforcement action that took place, it was around 2024, 2023. What has happened there? Essentially, they start accounting for every single breach in that context of so even if this was the same biometric information, but there were multiple scans, they were looking if the permission was extended for every single scan, and was it actually necessary to collect that biometric information for each instance when the data was being collected. So yes.
So sorry, do you have one more example, or were you just wrapping up that one?
I think we're wrapping up.
Okay.
This was just an illustration of the scope and direction. So I'm hoping that it was useful.
Well, that's great. Thank you so much for all that good summary of those actions and things for people to think about. And again, to the idea of building, privacy and how you handle data into the core of your topics. Wayne, if you could talk a little bit about data minimization as a legal defense, or as a way to make sure that your company isn't exposed to extensive liability.
Yeah, so I think the important thing to remember is that these are not necessarily just good things to have, and they're not just market drivers, right? You have GDPR, which expressly states that, and GDPR, as we all know and live under, is sort of that gold standard of personal information data privacy. And so they require data minimization, right? The statute requires that you only have and process and use the information necessary to accomplish the goal of collection. So you really do want to sort of build in this idea of not collecting and not keeping everything. So we all know, for example, when it comes to data breaches, it's not a matter of if, but when. If you don't have data, then it can't be breached. If it can't be breached, then you don't have fines, or you have fewer fines, and you have less of a chance, or at least fewer plaintiffs in a class action lawsuit. So you really want to do minimize data. The problem really becomes, what is the universe of the data that you are keeping? Business people always, like, my biggest argument with the business people is, we need that. It's like the most common refrain. We need that. We have to have that. Of course, then you ask why, and you get blank stares back at you. And data analytics groups, they want to keep everything because they're going to benchmark everything. They're going to use analytics for everything. They want a data lake that they can swim in and tell their grandkids about. And the truth is, you don't need all of the data. The data becomes stale. You know, when I think about the industry in which I'm in, which is sort of this asset tracking, which is logistics and telematics, the data from a year ago of how a particular container was delivered is stale, because you've got things that completely change how it's delivered. Take a ship traveling, from China to the United States or to Europe.
Through the Strait of Hormuz, for example.
Well, right. So you've got geopolitical considerations. You've got climate considerations, which change currents and change storms and winds. So like how a particular container went last year doesn't translate into how it's going to move this year. Now, the data analytics people will say, oh, but we can show changes. I'm like, but the truth is, if you talk to your customers and your clients, both internal and external, they don't want to know compared to last year. They want to know compared to next week what's going to happen. They want you to divine the future rather than tell you about the past. So you really do want to try and minimize data. Now, The problem also becomes where you start, and Abraham, if I'm getting ahead of myself, just let me know.
We can repeat. I think, one good thing here is just, we'll try to keep it short, but repeat important topics. So please, Wayne, go right ahead.
Well, I was going to sort of bleed into what one of the biggest risks are that no one's talking about, which is one of the topics of the discussion, which was inferred data, and how inferred data is data that you can't, that you need to minimize, that you don't know how to, because you can take data that exists, and if you analyze it, now it's inferred data about the same people that you've processed. Now you've got a new form of processing that you probably haven't done a data processing impact analysis for.
Yeah, I guess the question I would ask there, Wayne, is how often are you checking in with the business to make sure that
every day
the policies that you set last week, last year, are still purpose-built for how your products are being used now?
It's constant. It's constant because you've got the business people who are selling new products. You've got the engineering group who are trying to make new products. Privacy by design requires that you're in the process from the very beginning. So, you act like Jiminy Cricket, right, on the shoulders of your business, making sure that as we make new products and services, we're doing it the right way. I do want to say one thing. There was sort of a little bit of a gift from the Court of International Justice in Europe at the end of last year, and they redefined the definition of personal information, narrowing it so that personal information is now just any information that can be associated with a person. It has to be much more prescribed. Like you really can only, it's only personal information when it's identifiable. So if you've made information truly anonymous, then that no longer becomes personal information. And so that's really the goal, is that when you're trying to build your practices around it, I would push as strong as you can to anonymize the data, so then it's not personal information, at least for purposes of complying with personal data laws. And that once you don't have personal information, you're kind of off the hook in that regard.
Very good. Alesya, I think you're going to weigh in on this topic as well, and I saw you getting ready for that. So please jump right in here and give us some thoughts about this area.
Yeah, I think, as Wayne mentioned, GDPR used to be the gold standard. Now we have Illinois as the gold standard. I think anytime there's a stricter law, that becomes the gold standard. I've worked at startups most of my career. I will tell you, most product and engineering teams don't want the gold standard. They want the lowest standard that they can reach in order to go live with their product yesterday, right? So building in privacy by design from the beginning, building out a secure product lifecycle, making sure that you're not just the privacy team is in the room, but the security team is in the room. Using first principles of GDPR, data minimization, having a good data map, I think is half the battle in terms of figuring out where your data flows are actually going.
When you're trying to convince a startup team to use a gold standard to avoid risk and these types of things, what strategies do you use to try to get them to listen to you when it costs money?
I try to do a phased approach, is meet that lowest standard of the bare minimum requirements that we would need to meet in order to go live, and then have a phase two where we meet, certain other requirements on the back end. We still keep working on it. We try to automate things. So breaking it up into 2 to 3 different phased approaches for them so that it's not all things all at once going onto their roadmap. I think the roadmap already is filled with things that, they want to build cool stuff, not necessarily privacy by design or GDPR stuff on their roadmap.
So you try to tell them, hey, there's an easy button here in some regards, but what about fear? Do you put the fear of the enforcement mechanisms in front of them? Do you tell them these great examples that we've gotten so far about, you could have each private individual in Illinois have $1,000 in private actions if you collect their data in the wrong way, or that kind of a thing, I think, is an important part of educating a team, right?
Yes. Well, I think, trying to scare them is part of the education and the knowledge sharing, but that's also a great time to bring in your finance stakeholders as well, so that you can speak money with them and let them know that they also now become a stakeholder when it comes to privacy by design, because it'll cost them, right? What are the fines? What will this cost? what kind of, private actions can people take? What'll it cost in terms of litigation and using outside counsel to settle any of these? We've had a bunch of SEPA claims come out just because the cookie banner was firing off cookies after a certain amount of seconds, and they claimed that they didn't have enough time to actually make a choice yet, and that you were firing off too soon. And becomes a discussion of, okay, even in the US now, do you employ GDPR standards when it comes to cookies, even though you don't necessarily need to, because you're having things like SEPA claims coming out about wiretapping, using these old legislations for things that are now online, especially with AI. How do you translate these regulations and these practices now with new technology that just the regulation isn't actually keeping up with? And you mentioned, move fast, break things. That is the motto when it comes to startups.
Indeed. So in terms of retention minimization, anyone else here have any experience on this or thoughts about the idea of retention minimization?
Perhaps I will add only two things. So one, it's not only about privacy, it's also viewed by FTC as a security failure if that's not done correctly. So implication of not minimizing the data has long implications. And in the context of our subject that we will cover later on, shadow data, I think the huge arguments for the business to consider if perhaps some information should be tagged and deleted. So by the way, this is correct data governance. You should map it, tag it, and also have a proper retention policy governance thresholds for that, which adhere both to laws and to what exactly does your business need. But
are there particular sources that you use to determine those kinds of standards or policies, places that you go to try to, or have gone to try to find just a baseline first draft of those things that then can be customized?
Yes, very actually fantastic question. First of all, you need to understand in what business do you operate, because standards will vary not only based on jurisdiction where your clients are located, but also based on jurisdiction where you keep the information, and then based on also type of information that you have and a business in which you function. So let's say, is it healthcare or financial information, right? So thresholds for retention of that information would be different. Are you operating in the financial industry or healthcare industry? So you would need to go to regulatory pages and check how that looks like. To be honest, if you request assessment like that from external law firm and you have a global footprint, it will cost you a penny, that's for sure. But there are good sources. So what I would recommend, ORBCOMM. They publish a lot of studies which essentially have some general data privacy requirements mapping. So I would go to their page and probably I would take a brief glance. I would not use that as ultimate source of truth, but if you want to just have a quick cheat sheet, that would be the place to go.
Great. Anybody else have any?
Hey, Abraham. I did want to just add one thing. It's not just laws and rules and regulations. So a lot of companies negotiate by contract specific company data retention requirements. So for example, for us, we have a lot of oil and gas companies, and they have very strict rules about deleting their data on a 6-month rolling basis, for example, and that's going to be by contract. And so you have to make sure that, your IT team is aware of the contractual obligation and tags the data for automatic deletion. So it's not just sort of external obligations, but internal, contractual obligations that are often missed because it's not communicated in the same way.
Absolutely. I think that's really important to think about. So in terms of modern machine learning and what it requires, I think we had talked a bit about this. Does anyone else have any thoughts about how, and there's also a question from the audience actually for Wayne. it says, when data is anonymized or depersonalized to reduce privacy risks, what measures do you recommend to prevent models from generating decontextualized decisions, especially in high impact areas such as employment, healthcare, education, or credit?
So it's a great question. I think part of it is what I said, part of it is also what Ava said in regards to what you're required to do. So in some contexts, like finance, you're required to delete data. Again, like you don't have a choice. It's not a question of like anonymizing it. You have to delete it at a certain point, and it has to stay identifiable for the period of retention because you have compliance obligations. For things like internal information, like employment or potentially healthcare internally, again, like in the United States, healthcare is governed by HIPAA. Those statutes define how, with the where, the how, the who, the what, all of that details. And so it becomes a statutory compliance issue rather than a company specific sort of, are we meeting market needs or customer needs? But I will say, you know, we, for example, stopped allowing our customers to include identifiable information in our platform for drivers of vehicles, right? So like, so for us, we no longer have access to any personally identifiable information. We can see a vehicle and it has a hash or a salted identifier, which is entirely meaningless to us. And outside of the platform, you know, our customers can identify that. But for our purposes as a processor, what's critical for us is we've got no way to identify that person.
Like in cryptography, when you have a handwritten key at your house, which is a book or something that
that's right.
You know, so the people who are on outside of what you store are the only ones who could actually create the personal connection. So that's right. That's a really good solution.
And the other thing too, just to remember, just for some perspective, so like GDPR came out in 2018 and they were shockingly prescient enough to not include specific requirements for compliance, right? They said use whatever is the most reasonably available, technologically advanced mechanisms based on the kind of data. So, you know, your name, everyone's names that's being disclosed, that's not particularly sensitive, but maybe your national ID is. Different data requires different levels of protection. And as technology changes and advances, the statutes require you to essentially keep up with the Joneses and keep up with technology.
Very good. So Ava, I think you had a comment about the AI paradox.
Absolutely. So this is such a hot subject, and it's so relevant presently. So few things. When you asked about training AI models and how we would prevent this information from resurfacing, you really need to understand the LLM that you're using. You really need to understand the models that you're building and technology that you're dealing with. The reason for that is the risk will differ. So you have, for example, AI models like random forest. So that will extract only information which is related to creating a decision trees. That particular model is much less likely to disclose the information. So like, for example, the enforcement cases that we have seen in the context of OpenAI, where it appeared that essentially information that the model was trained on resurfaced. It's much less likely in a case of a model like random forest. So you need to understand that essentially how that information is being consumed and retained within the model itself. Another thing that I would mention is to understand the concept of bad training data in a context of AI. It is super important for two reasons. First of all, you can lose you can be not only in problem because of the privacy situation, but you also could put yourself in problem because you cannot use that model. If so, there were cases, enforcement actions by FTC in 2001, which was related precisely to that, where there were some portion of the data that the systems were trained on were legally obtained and had proper consent, and some of them didn't. And it turns out that it's not even necessarily intentional action. Let's say some employee saved somewhere and saved some shadow data somewhere that was not accounted for, and it became part of the pool of training data and contaminated it. So you may not be able to use the model if essentially you are not going to make sure that you have a proper controls and proper track record of information that was being used to train it. OpenAI, the case from 2024, for example. So what has happened was that was enforcement GDPR related violation. So Italian regulator found that OpenAI lacked adequate legal basis and transparency in processing personal information by ChatGPT. So this was including training related issues. So the key in interaction with AI in a context of privacy is you need to have a proper consent. You need to know proper, you need to also give proper notifications if it's necessary in some jurisdictions, and make sure that essentially you have a clear line of visibility into that this consent was obtained for all the information that you are going to be using for training, not for, let's say, data lake. So if I would say, oh, I have a consent, I purchased this data lake, and I have, I can evidence that essentially, you know, I'm relying on the party that is handing off to me this data lake, but I don't exactly know.
I guess that's a good question to ask the panel in general. When your company is buying a data lake, what types of protections do you make sure are in the contract to protect your company from risk from third parties? Taylor, do you have any experience on that, or any, Alesya, or I think we lost Wayne. Oh, Wayne's back. So yeah, so in terms of protections in agreements, do you guys have any thoughts on that? Taylor, I'll have you start on that.
I mean, I think that's a really good question. I think if you were going to purchase a data lake, the first thing that I would ask is, you know, for what purpose? And I would be curious, so coming from a health background, I would want to know, you know, how do we know that they had legal authorization for all the data that was in there? I think it can be a really hard road to go down. So typically anytime you do like a large purchase, you need to also, not just want to, but you need to do due diligence for any type of acquisition that's going to be an integration.
Right. One thing that I thought about in that context is you actually might want to read the terms that the data was originally collected under to make sure that the purpose is actually could be determined to be part of what that you know, and also how those terms were presented to the user. So sorry, go ahead.
Yeah, I just would say, I think realistically in the health space, I think that's going to be really difficult to be able to, if you want to purchase a large amount of data, I think that it's not realistic that you're going to be able to do a trace of the informed consents to a data set. And I think that any counsel will probably advise you on that. And so then you have to do a risk assessment of, you know, do you want to do that due diligence and find that it's not present and document it and go forward with the purchase? So, you know, it's interesting because a lot of really large medical device companies that have built their machine learning algorithms have built it from the purchase of big data sets before there were so many privacy laws. I mean, it's a very interesting topic. I could talk for this.
No, I just think it's really, a long time. It's something that our audience needs to hear, I think, a little bit about in terms of, is there a risk? Because, you know, is there actually enforcement going on in this space? And then also, you know, the reward part of it, of, you know, a lot of customer terms you see, at least that I see in my work coming back, are trying to be extremely limiting on the use of data in training AI. And so I think it's just really important to think about these things of how do we develop our products, how do we mitigate those risks and so forth as part of what we build into how our products are developed. So go ahead.
Yeah,
Corner?
I mean,
Sorry.
I was just gonna say from an enforcement risk perspective, I mean, it's not as large as you would think would be. That's my perspective, but there has been some algorithmic disgorgement cases, like Ava was saying, in the health tech space, other spaces as well. I think the best thing that companies can do is to always do due diligence before bringing data sets into their company, and really document that due diligence, and then have those terms and conditions in the contract that the other party rep and warrant that they had legal authorization to obtain the data, and then tag the data properly when you bring it into your organization, that this data set came in under this legal authorization for the use of this purpose. And I know that sounds really simple, but shockingly, a lot of organizations don't yet have the IT technology to be able to do that, or haven't evolved their BD processes for that. And that, I think, does put you just at an incredible risk. Yet at the same time, they want to go into the digital space or advertise having digital capabilities. And I think those are the companies that are the highest risk, in my opinion.
Alesya, we had talked a little bit about the issue of cross-border and bulk data transfers. So I wanted to give you a chance to kick that off, and then we'll ask some others to weigh in there as well.
Yeah, the number one thing I ask for at during contract stage, and hopefully everything Taylor's just mentioned, the due diligence is done before you get to the contract. So hopefully your third party risk management or your compliance team is doing this during the RFP stage and getting that information so that they can properly choose a vendor and
I guess
tooling
we
that
could take one
has
step
that
back
stuff.
there, just for the people who haven't dealt with this before. You have the RFP stage of who's going to provide data and who are your partners and how are they going to be utilized, right? And
right, so they're
and
gathering
so
the
you'll work with your
information.
product development team to create some kind of a script of what they
Questionnaire,
want.
right?
Yeah.
Figure out what implementation looks like, and sometimes I'll join those calls if it's a high risk vendor to ask the questions that Taylor mentioned in terms of, where are they gathering their information? What kind of terms did they have? What kind of consent did they gather for that information to begin with? A lot of the times the people on the call don't have the answers. They'll get back to you if they don't have the answers. You mark that as a risk in your RFP as you're choosing the right vendor for that. And once you get to the contract stage, I always ask for a sub-processor list to be included with our DPA to figure out where their third parties are doing business and who are they sharing information with, so that we can understand our global risk, because then we would need to update our own sub-processor list depending on that, right? A lot of the times they don't have that list, or they'll tell you they're only US based, but then when they provide you that list, they actually share out information and have systems in many different countries. Always important to ask for a sub-processor list.
And how often do you update that, or how often do you ask companies that you're in contract with or using as part of your service to update their list?
So part of just regular maintenance, we check on a quarterly basis, but if we have any sort of vendor that we're onboarding that we're going to be sharing out information and they're not just US based on that sub-processor list within that agreement, we need to go in and then update our sub-processor list and send out 30-day notices to our customers. So it becomes a trickle-down effect. So that's why we try to get to it a lot earlier than we can.
Wayne, I think you had something to add here. Please go ahead.
Oh, it was just in relation to the previous discussion.
No, that's okay. I'm just saying, just go back to it and say it to the whole group. Not everybody is reading their comments as much as I am, so go right ahead.
Yeah, just super quickly, the Europeans try to address secondary uses of data. So if you're buying data lakes and things like that, the EU Data Act tried to address it. I don't think they did a great job. There are some scary things in there, like how the government can basically decide they need to use your data for whatever reason, and then they can sort of force you to give it to them or to a third party if they deem it appropriate. But more specifically, if you're buying large amounts of data and particularly acquiring it in an M&A context, because you're buying a company with a large amounts of data, the truth is reps and warranties are great, but we all know they're only as good as the pockets of the people giving it. So I would just, you should consider cyber data and cyber insurance. And there's some really good companies that provide, specific coverage for data. With the understanding also, you can't insure against regulatory fines, right? That's a moral hazard. So you can't insure against that. So that's where everything else that Taylor said, comes into play.
I think it's really important to buy sufficient insurance and all things, but also having worked in insurance defense and insurance litigation, understanding what the exclusions are in the policies, how those policies are actually applied in practice is extremely important, because you need to make sure you're paying for value. And you can negotiate those things with an insurance company to say, look, we do need coverage. How do we get it? And the other thing about dealing with insurance companies, just as a general rule, I tell everybody that I mentor about this, is when you're talking to an insurance broker or an insurance company, get everything in writing in an email. What they tell you on the phone is not worth anything. You need to make sure you get them to write it down. So if they say this is covered, thank you, write it in an email to me, and I'll keep that in my files. So in 2025, the DOJ's bulk data rule took effect. And that restricts U.S. companies from transferring data to, sensitive personal data, health data, et cetera, to various countries of concern. Does any one of you on the panel have any experience regarding this or any further information? China, Russia, Iran, North Korea, Cuba, and Venezuela are the countries that are, I think, currently on the list. But any other information about this that we should share with the audience?
It's a big challenge for a large corporate that have an international footprint. And each time you really need to figure it out, essentially, what those restrictions are and what should be your strategy. In some cases, companies decide even to create subsidiaries in a given country because they cannot cope with the international risk, and there are limitations on data transfer between different countries, especially in financial industry. That's the case in case of sanctioned countries. On the other hand, if you are a global corporation, you will always have challenges around the fact that you have to have visibility into your clients that have a global footprint. So let's say I'm in US, but the client has accounts both in US and in China. And I need to conduct my due diligence on the client and have access to their data both in China and in US, but I cannot have that visibility. So my teams cannot have that visibility cross-border. How do I solve for that? So very often you need to even consider it from a operational perspective. Sometimes you have clients that, regardless of the international regulation, they refuse or they have negotiating power of saying, I don't want to share that you share my data cross-border. So they essentially, in some way, also need to be treated differently. So in those cases, if you are a large corporation, you will essentially, in a context of privacy, you essentially need to have a local teams from operational perspective to access that information. And from a sharing perspective, cross-border sharing perspective, when I need to, let's say, inform the team on the other side about existence of certain concern related to that information, I also need to consult the local laws. To what extent can I do that? So let's say you have a screening concern as far as the client. There was some enforcement action, local enforcement action. China presents that problem because they have a lot of local agencies that essentially generate a lot of different types of enforcement actions against individual companies, but it is not accessible or visible externally. So operations team needs to handle that internally, and you need to have a conversation, sometimes even with regulators, of what can be visible to rest of the global company. Just
Sure, I'm sorry, I'm
alert,
gonna
for
have to
example.
cut you off there,
Yeah.
Ava. Wayne, if you
Yeah.
could talk a little bit about inferred data, and I know we got to this a little bit earlier, but talk about sandboxing data for each customer, talk about your best practices around this topic. And then in a couple minutes, we're going to open up the floor to questions. So I posted something in the chat to ask people to please post their questions there so we can make sure to try to leave time for those. But Wayne, just a couple minutes on inferred data, please.
Sure. So I'll try to be brief, which is hard for a lawyer. I'm sure everyone knows.
No. I'll cut you off if it's going too long. I don't see any questions yet in the chat, so I'm feeling like we may have to, we may be able to go to the end. I'd be happy to get questions from the audience, but people are being reserved at this point, or we're just answering everybody's questions and nobody has anything else they want to know. So go ahead, Wayne.
So look, inferred data is derivative from your underlying data. So the first thing to understand is inferred data is data, particularly personal information and personal data. And that is something that is important to again, like the biggest hurdle that I face, for example, is making sure that the different teams understand what personal data is, what confidential data is, what proprietary data is, and how they all overlap. Again, going back to that ruling at the end of last year, one of the things that the Court of Justice really focused on is that, like, personal opinions, for example, things like in surveys, right? Those are the results of those are the inferences from the responses. And the thing is, you could be asking, for example, well, how do you feel about a political candidate? And so you get all the answers about how a person feels about a political candidate, but then you infer the political position of the person answering the question, depending on who they like or who they don't. And even if that data is anonymous, if you can re-identify it, or if it's reasonably feasible to figure out who this is about, then that's personal data as well. So in the context of commercial data, again, you're using, and AI is the biggest sort of, I'll say, problem with this, because AI is allowing companies to create new forms of data and new data sets arising from the inferred data, and very often in ways that commonly you wouldn't necessarily associate different things. One thing that we do, again, depending on our customer, larger customers in smaller industries, they say, well, look, you can infer who we are and what we're doing just because we have such a large footprint. So when Aram said, we're sandboxing their data, what we're doing is essentially we are segregating their data from all other data. And then we are not including that data in our benchmarking because it would skew the data and the analytics so much that it would be impossible for a reasonable person, forget using technology, because using technology, as technology gets better and as AI gets better, your anonymous inferred data is more easily translated into identifiable data. So you've got a double-edged sword here with how technology is allowing you to do it. I think the most important thing is that you have to have these discussions with your teams, with your development teams, with your data teams, with your security teams, with your salespeople. Get the data rights from your salespeople by contract. Get your development team to understand that, the data that they're creating today is personal and private today or anonymous today, but technology can make it identifiable tomorrow. You've got to have enterprise-wide conversations and training so that everyone understands and everyone's on the same page. And you've got to get the messaging coming down from the top, because I'm sure everyone's heard this in every seminar or every panel that you've been on. The messaging, regardless of the industry, it has to come from the top that this matters.
AJ, I've seen you come back on the screen here. Are we is that our cue to wind up, or are we able to go the last 5 minutes? I know we need to open the floor for questions.
I think we still have 5 minutes. Yes.
Yeah.
Exactly.
So
we still have 5 minutes.
Yeah, let's open the floor for questions. I think, Wayne, that was a good way to wrap it up. Is the message needs to come from the top that privacy is important, that how you store and use your data needs to be managed closely, and you need to be, checking on these things at least on a quarterly basis to make sure that you don't have any risks that you're unaware of that you should be mitigating. So I don't see any questions in the chat, but AJ, if you can, encourage people. I don't know if you know anybody you want to call on in the audience, but we're happy to have questions from the audience.
I think I've already done that. You have asked the audience to put in their questions if they have any. But if they don't have any, then I think if any of you would like to share any closing statement or any thought points, anything that you would like to share.
No, I think, in terms of our notes and what we had talked about in our prep call, there are so many conflicting and new areas of legislation coming out in this field that it is very difficult to make sure that you're harmonizing all of those various things. And so just, make sure you're being vigilant, make sure that you're talking with your teams about how they're using data and trying to mitigate your company's risks. We lost Ava. She's back. Oh, great. So anybody on the panel have any closing remarks? I think we just have maybe 1 or 2 minutes left. Taylor, yeah.
The last thing I wanted to say is I know a lot of companies are working on a data governance documentation, and I would just try to evolve that data governance documentation to be able to encompass the inferred data risk that we've talked about today, specifically tailored for whatever type of product or industry you're in. So if you're in health tech or fintech, think about if you're doing machine learning, what are potential inferred data risks that the algorithms could be creating, and then have a data governance checklist.
Cut you off. We have one question from the audience, so I just want to make sure I value that question. Yash has a question. What's the one thing a legal team should do first if they suspect shadow data exposure? So anyone on the panel want to jump in on that one? Taylor, I know you had the floor, but anybody else want to jump in on that? Okay.
Exposure, cybersecurity.
Yeah.
So it depends obviously on the organization of your company, but if you use the word exposure, meaning that something may have been disclosed, I think that's the first thing that I would take
I would take a step back from that and say you're starting your timeline a little bit too late. If the first thing you're doing is when you find out there's exposure, you should be running tabletops and have a clear plan in place for how to address this, because it's not a question of if, it's a question of when there's going to be some exposure of some data. So I think it's just really important. One, as we talked about from the cybersecurity and perspective, two, from the insurance perspective, and then obviously internal practices that prepare you in advance for something like that. Now we have another question at the very end coming in, but I'm not sure we have time. So AJ?
Yeah, please go ahead. We can take the question.
Okay. How are inferred data generated by AI trained particularly with fake poor information a risk for regulation, considering that the inferred data won't be accurate and are real at all? I'm not sure. You guys see this question? If anyone
I can grab this.
Yeah.
I can grab this quickly, Abraham. So I think the mistake is that you're looking at and quantifying the quality of the data and looking at it in that context. Data is data, and the kind of data it is what governs what it has to comply with. Whether it's good data or bad data, it isn't relevant. So if it's inaccurate and it's published, then it could be defamatory, for example, but it's still personal data. And so if it's personal data or finance data or health data or biometric data, unless it's, like an AI generated image of a face, right? And then it's not a person, so it's not so there really isn't anyone to bring a claim, and a regulator's not going to. Yeah, I assume, Ava and Taylor, you guys are more expert on this. I assume a regulator is not going to bring an enforcement action for posting a picture of a non-existent person, and so the quality of the data isn't really the focus. It's the nature of the data, and what category that data fits in. And then the regulations are the regulations. So
and how it's being used and commercialized, et cetera, right? So,
yeah, I would
Taylor,
avoid
you had a
looking at.
comment? Yep. Taylor, did you want to say something about that?
No, I completely agree. I think it's highly sensitive data. And yes, how it's being used if you had the proper consent to use it. And that's the analysis that has to be done.
Great. Okay, well, I think we're at time, and unfortunately, I do have my next meeting I have to jump on. But AJ, is there any other closing remarks that you want to give before we wrap the session?
Yeah, definitely, Abraham. Well, I would like to thank all of you, for bringing in such a lovely discussion on the table. It was actually really wonderful. And to you, Abraham, special thanks to you for, expertly moderating today's discussion. And sincere thanks to all our speakers, Eva, Alesya, Wayne, Taylor, you all were wonderful. The kind of experience you guys have and the perspective you brought on the table with your experience-based perspective, it was simply amazing. Now, before I let all of you go, I'd like to inform all of you that, we have our upcoming conference in New York City next month. That's on 23rd and 24th of July in New York City. Now, this conference will actually bring together, leading legal professionals, in-house counsels, law firm partners, compliance leaders, legal innovators, from across the globe. It's a two-day thing. It's a two-day conference, sort of full of leadership, thought leadership, networking, knowledge sharing. And we will also be hosting Legal Honor Global Awards at the conference. Now, this award will actually recognize excellence and leadership across the legal industry. And we will also be hosting an exclusive cocktail reception, providing a relaxed and enjoyable setting to connect with your peers, industry leaders, and fellow attendees from around the globe. So looking forward to see you all over there so that we can continue this conversation. So welcoming you and the audience at the conference. Thank you, guys. Thank you for the lovely session.
Thanks so much. Bye-bye.
Thank you.
It's a pleasure. Thank you.
Bye.
Well done.